All right, I'm just going to bust through some questions some of our medical justice and eMerit plan members have given to us. So for example, if a patient dies, their assumption is that HIPAA doesn't rule any longer. Is that accurate?
It's not. You have to go with who is in charge of the executor of the estate, or the personal representative, depends on what state you're in, has control over those records. You can't just turn them loose. HIPAA does not end at death.
So HIPAA continues living forward after death for some period of time. Is that correct?
That's exactly right.
Wow, it sounds like there are a lot of details related to HIPAA that aren't particularly intuitive.
Unfortunately, the devil is always in the detail, right? And this is an area of law that there's lots of detail.
Okay, I've got one more that I had been led to believe, and it sounds a bit crazy. Help dispel this myth. I understand that if you send an email to a patient, that is not kosher, but to the extent that you send a fax, that's okay. Is that correct?
Oddly, I think you're right. You can send emails in certain situations, but the email comes under both HIPAA and the High-Tech Act, where the fax does not. So it's outside of these rules. Now, in today's world, we have faxes that go through email accounts and so forth. So the distinction seems very odd and archaic, and I think that it is. It's just another example of how people can get in trouble, or how this rules and regulations are confusing.
So many patients, and at least people that I know, want to communicate through email. They want to communicate through texting. What does a practice need to do when they see a patient to determine whether they can safely communicate by email or by texting?
Well, I recommend that you get the patient's permission to do that. Certainly, if the patient initiates the communication, you're able to respond in the fashion that you were contacted, right? So if the patient sends you an email, it's assumed that you can respond to that email without any kind of problem. If you want to initiate the conversation, then I think that you need to have the patient's permission to do so.
So by permission, you mean a very particular formal type of authorization. Is that accurate?
That's right. That's exactly right.
So people can get in touch with our organizations to get a template of such a release. Is that correct? Or authorization?
You're exactly right. They certainly can. And this is not an area that is terribly difficult. The problems come about what you don't know, right? And so this is an area that hopefully we've identified these risks and provide easy solutions for people to implement in their practice, so they just keep them out of harm's way.
Is it enough to have in the intake form a document which says, I give permission for Dr. Segal to send an email to me? Is that adequate, or does it really need to be a bit more involved than that?
I think it needs to be a little bit more involved. We need to talk about what type of an email. Sometimes people do not want certain types of health information sent. Sometimes they only want them to go to certain email accounts. So there needs to be a little bit more in depth than what you just proposed, but you're certainly on the right path.
For more information or to join our mailing list, sign up at info@medicaljustice.com.